So let's, without any further ado, get the expert legal opinion of the one and only Kendall Coffey as we go spinning the law. Hello, sir.
Hey, Steve. Happy holidays.
Same to you. Thanks for coming on today. I do appreciate it. Hope you had a good one.
Yeah.
Okay.
It's been great. So, you got some good topics.
Yeah. Well, let's talk about the gay marriage situation here. And as I pointed out a second ago, all these states usually through the judiciary recognizing now gay marriage or having their ban on it ruled unconstitutional, all since the 6 months ago, the decision by the U.S. Supreme Court. Most recently, we have Utah, and now it looks like after being turned down again by a federal appeals court, Utah wants the Supreme Court to weigh in on this, and I believe it goes to Sonia Sotomayor.
Yeah, and most are not expecting her to reimpose the ban on gay marriage in Utah. I think what we're in the middle of is an inevitability, a legal inevitability, because the cases consistently seem to be landing in favor of gay marriage, so much so that some have asked, why hasn't the Supreme Court simply selected one of the cases, chosen an opportunity to speak, and settled the issue once and for all? Why is this sort of being battled out state by state? All the more so when they could have perhaps some 6 months ago maybe addressed it when they had two major cases on their dockets dealing with different aspects of gay marriage. I don't think there's a clear answer, but it wouldn't surprise me if the Supreme Court wants to get a little bit more development in the law, and that they themselves may still be somewhat divided on the issue, because I think for a court that includes 5 conservatives, this is not an easy question.
Do you? I mean, are these courts in the various states? Do you believe that it's a question of liberal judges, or that it's a question of feeling social pressure, or do you believe that they're going strictly on the law?
Well, I think they're trying to read into the U.S. Supreme Court's decision on DOMA, the Defense of Marriage Act, some language that seemed to be supportive. Not directly, but seem to, in general terms, be supportive of a constitutional right to gay marriage. And I also think the judges at every level see this as inevitable, and that this is where the law is going to go sooner or later. And judges, some of them may not want to be seen as resisting what is portrayed by many as a civil rights issue that is going to eventually end up being determined in favor of gay marriage. When will the Supreme Court step into it? I think within the next couple of years we'll see a final decision from them.
It's very interesting. And again, you don't think it doesn't matter? You think to the Supreme Court? I mean, we hear about how certain justices are influenced by decisions in other countries. They've actually come out and admitted, and that's usually liberals on the court that say they look to other countries' decisions on how to treat issues that come before them, which I find to be just bizarre and outrageous. But do you think it enters into it at all when these justices, especially maybe the conservatives, see that whenever states vote, when the people vote on this, it's usually to ban it and to keep marriage and define it between a man and a woman, and that these judges in these other states are overturning what you might call the will of the people. Does that enter into a Supreme Court decision at all, do you think?
Well, judges will say that they're indifferent to the will of the people, that they don't read tracking polls, and yet I think all of us have a sense that they do indeed care about what the public thinks, even if it doesn't directly specify an outcome of a case. Opposition to gay marriage, according to some polls, seems to be slowing down. And if it gets to a sufficient level where the Supreme Court thinks that there is, in effect, a national majority supporting gay marriage, I think at that point take up the question, and they'll take up the question and answer affirmatively in favor of a constitutional right to gay marriage.
We're talking to Kendall Coffey here on the Steve Malzberg Show in our Spinning the Law segment. Let's move on to this case in Texas. There's this case of a woman who's 33 years old. They already have a child, her and her husband, and she got up in the middle of the night to give the kid a bottle, and she never came back. And the husband then got up and found her unconscious and not breathing and turning blue from lack of oxygen. Long story short, she is being kept alive. Even though the family want the plugs pulled, but she's pregnant, 14 weeks pregnant, and there is a law in Texas, as there are with the statute in other states as well, I believe, making it illegal to disconnect life support from a pregnant woman.
And the family is frustrated with the law. They're considering whether to, in effect, file a court challenge. And I guess the essence of the court challenge would be that she has this tragically impaired woman has some right of privacy to determine and affect her own death with dignity. What I haven't seen developed in the law, and certainly other people who are not carrying a human life inside them, no question can provide living wills that specify that in certain conditions, especially where someone's brain does not seem to maintain cognitive force, that person has a constitutional right to provide directions for the termination of their life. But this situation, I haven't seen a court that says that she has the right to terminate in that situation not only her own life, but if in doing so it eliminates the life of an unborn child, that is a decision that has to be accepted. Nor do I know, and I haven't been able to find the details, whether whatever directive she gave specified a situation where if she were pregnant, would she still want her own life terminated? So I don't know that this is a situation that she and her family would have anticipated at the time the living will was given, but I would suggest it from a constitutional standpoint where she apparently does not have cognitive force anymore, and she's being described as virtually brain dead. It seems to me that there has to be a greater balancing constitutionally and a greater respect for the life of the unborn child where her own life is so irretrievably damaged. This is not the normal situation of a Roe versus Wade, where you have a healthy, vibrant person in full possession of their powers who chooses to make a decision and invoke a constitutional right of privacy. This is someone who's no longer capable of making any decision at all. So in that situation, do you override the laws of Texas, which says that if there's an ability to keep an unborn life to maturity, then that's what the law requires. So I think it's very different than any of the cases we've been reading or talking about.
Yeah, absolutely. And according to a report from the Center for Women's Policy Studies, 31 states have the laws that allow hospitals to keep women alive against their wishes if they're pregnant. And from what I understand, you know, the woman's brother had died several years earlier, and they all talked about how none of them wanted to be hooked up to machines. But, you know, I find it hard to believe you could walk into an emergency room with a woman in that condition and say, well, she doesn't want to be hooked up, so don't hook her up. I mean, they have to have more than that. And plus, if she's pregnant, I'm with you. I mean, I don't know, because women have abortions, and I don't understand that. But I can't imagine a woman who says, you know, yeah, if I'm pregnant and I lose consciousness or whatever, and they need to plug me in to keep me alive, to keep the baby alive. Don't plug me in. I don't want the baby to be born. I mean, that's quite a complicated issue, and I just don't see most women weighing in on the side of, no, I don't want the baby to be born, especially if she's married.
Yeah, I think it's a fundamentally different question, and I don't know that there's any evidence that she said, yeah, even if I have an unborn child, I still want life support.
Right. No, there is no evidence presented as far as that goes, and I think the laws in 31 states, if that is accurate, I think that's a good law to have.
Well, it's certainly a very different constitutional question where, as we know, there's a lot of discussion between balancing the prerogative, the privacy rights of a woman in a stage of pregnancy, and then with the life as it evolves inside her in the later months, especially in the last trimester. Here, if you look at the balancing test, it's a much more difficult question where the life of the mother that one would want to constitutionally protect is in many, many ways utterly destroyed, that the only life that is left to be protected and respected in this situation may be the life of that unborn child.
No, that's a brilliant point, because you're not talking about protecting the life of the mother. You're talking about ending the life of the mother. That's absolutely true. And we'll pull the plug after the baby's born if you could keep the baby surviving. But like you said, and again, then if someone, there have been murder cases certainly where a pregnant woman is killed along with her unborn baby, and they charge the perpetrator with 2 counts of murder or homicide. So in many cases they do consider the unborn child to be a life. Let's move on, Kendall, to the last one here, and that is. I didn't know that you could sue the makers of a movie because they portray you in a detrimental light, or what you perceive to be a detrimental light, and that's the case in New Jersey, where members of the Ramapo Native American tribe have filed a $50 million lawsuit against the makers of a recent Hollywood movie they say depicts their people in a negative light. They got a prayer here?
I think it's a really tough lawsuit. Can you imagine all the lawsuits that we lawyers would have filed by now if people who portray lawyers in a negative light were violating something? My goodness! And you can the laws of defamation are much more demanding than I think these plaintiffs will be able to establish. I mean, there's so many legal issues that seem to stand in the way of this group of plaintiffs and any success in a courtroom. But I just hope that no one tries to disparage outstanding radio announcers as a group, as a classification. But if they do, Steve, you got my number.
There you go. Yeah, I don't know if I can afford you, but I got your number. Yeah, absolutely. Hey, Kendall, really appreciate it. And we'll talk next week if you're around after the new year. We'll kick off the new year with you. What better way? And have a great one and stay safe, sir.
And you too, Steve.
All right, thank you. Week. Kendall Coffey here on the Steve Malzberg Show, spinning the law. Yeah, I mean, this, I never heard of this group, but the federal suit was filed Monday in, of course, New Jersey, against the writers and producers of Out of the Furnace. That's the movie. The suit claims the film makes false representations about the people who live in the Ramapo Mountains along the New York-New Jersey border, about 25 miles west of New York City. It claims that unsavory characters in the film have last names that are common among the Ramapo tribe, and that it perpetuates negative and unfounded stereotypes. So every ethnic group, every group portrayed in a movie, they don't even have to be ethnic, like Kendall just said, lawyers. I guess you could sue, right? Just get together and sue. Crazy stuff. Crazy stuff. What can I tell you? Maybe they'll win for all I know, because after all, it is New Jersey. All right, when we come back, we have some very interesting things to tell you, including a fictional matchup between Hillary Clinton and Chris Christie, and Hillary Clinton and other Republicans. All that straight ahead, right here on the Steve Malzberg Show, Newsmax TV and radio.